The Independent Electoral and Boundaries Commission has moved to the Supreme Court to challenge the Court of Appeal and High Court decision on the Commission's quorum. IEBC wants the Court of Appeal's decision set aside, saying it threatened the independence of the polls body and that the decision to declare the Commission non-quorate was based on a non-existent law. Chemutai Goin has more.
After the Constitutional Court and the Court of Appeal declared the clamour for constitutional review through the BBI null and void, several attempts have been made to salvage the bill. So far, the proponents of BBI and the Attorney General have lodged appeals in the Supreme Court. The latest is the electoral body IEBC, which has also moved to defend its quorum question after the two courts declared that the Commission was not properly constituted when it audited signatures availed to it to kickstart the constitutional review process.
The Independent Electoral and Boundaries Commission does not have the requisite quorum for purposes of carrying out its business relating to the conduct of the proposed referendum, including the verification whether the initiative as submitted by the Building Bridges Secretariat is supported by the requisite number of registered voters in accordance with Article 257(4) of the Constitution.
In papers filed at the Supreme Court Registry, IEBC wants, among others, the composition of the Commission addressed. The other decision being contested by IEBC is the question of public participation in the referendum push and the role of the Commission in facilitating a referendum and in delimitation of boundaries. In the documents, the Commission expresses its dissatisfaction with the decision of the Court of Appeal, claiming the findings by both the Court of Appeal and the High Court were based on provisions that did not have the force of law. In fact, they claim the appeals court relied on a non-existent law and should therefore be overturned. Further, IEBC states that the judges misinterpreted IEBC's role in verification of signatures. It further avers that the manner in which the High Court and the Court of Appeal interpreted the role of public participation of voter education was erroneous to the extent that it imposes upon the petitioner an obligation to take a partisan role in the process of amendment of the Constitution by popular initiative. With the court having ruled that the promoters of the bill violated the law, IEBC declined the court's assertion that it was meant to guide the proponents and ensure compliance with the law. The Commission went ahead to term the decision of the appeals court as incoherent, contradictory, and inconsistent. The Commission urged the Apex Court to dismiss the final orders, which they say threaten the functional independence of the appellant. In the meantime, three scholars, Professor Rosalind Dixon, Professor David Landau, and Professor Gautam Bhatia, moved to the Supreme Court seeking to be enjoined as friends of the court through their local counsel, Barbara Kwanga. The professors say they are experts in comparative constitutional law, their work cited by all parties of the High Court and Court of Appeal. IEBC also wants the court to interpret its mandate on key issues relating to the conduct of a plebiscite. Chemutai Goin, Citizen TV.